All right, I think we'll get started. Thank you guys for everyone who's on today. I think we are having a little issue with the Zoom link for some, so I'm getting that fixed right now, but this is being recorded, so we'll just get rolling. My name's Ashley Levinsky. I'm the executive director of the University of Wyoming Firearms Research Center, and we are excited to have Brandon Beck here today as our speaker for our December webinar. Brandon Beck is an appellate advocate and expert in federal criminal law. His scholarship focuses on federal crime policy, legal history, the Second Amendment, the Fourth Amendment, and statutory interpretation. As an advocate in 2019, Professor Beck argued and won United States v. Davis before the U.S. Supreme Court. In 2024, he co-authored the Supreme Court merits brief for the respondent in the United States versus Rahimi. And in addition to his work before the Supreme Court, Professor Beck has argued 15 cases before the United States Court of Appeals for the Fifth Circuit, including an argument before the en banc court. En banc court. Apparently, I can't talk today, the Friday before a holiday. So, Brandon, I will pass it off to you. And the way we're going to do questions at the end of this is we're going to try for you guys to be able to just unmute yourself and be able to ask the questions. If there's any issues with that, feel free to message in the chat and I can ask the questions for you. But we're going to give it a try for people to basically just call out. So we'll give that a shot. All right, Brandon.
Well, thank you so much, Ashley, and thank you to George and everybody else involved and that's invited me. I'll just say, because I'm screen sharing, I can't see everybody's faces, so I'm kind of staring into the void. So if you just raise your hand, I won't be able to see you. So just interrupt me if you have a question or there's a different kind of side topic that you were wondering about. So what I'm going to talk about today is kind of something I've been thinking about for some time. I'm no longer an appellate attorney with the Federal Public Defender's Office. Now I work at Texas Tech University School of Law. I've been there full time. This is my third year. And when I left the Federal Public Defender's Office, where I was an appellate attorney for about 8 years, it kind of put me into a period of reflection, kind of thinking back on the work I had done and also kind of meditating on how things have changed over time in just the 10 years from when I started until now. And then kind of speculating about whether federal crime policy used to be different than the way it is now, and if so, how different and in what ways. And so that led me to this project, which I wrote in the form of an article, and then I've got the second half of it coming out called How to Start a War on Crime. But in this piece and in this presentation, I'm kind of trying to tell a conceptual story about federal crime policy as applied to firearms crime. And so the title is kind of scandalizing, in a way, federal war on guns. But the reason I titled it like this is because I do think there are points of connection between federal crime policy against firearms and federal crime policy against drugs, at least as it was in the 1980s and 1990s. And so I'll try to point out a few of those points of connection, but really to try to tell the story of how we got where we are today in terms of federal crime enforcement. Of course, as an appellate attorney, I always think of everything in terms of trends or trajectories, because of so much of what we have to do is to be able to predict what's going to happen in the future, because we have to be preserving those arguments now on something that the Supreme Court might decide 2 or 3 or 4 years from now. And so much of appellate work, at least for me, has been trying to see where the court is moving, particularly the Supreme Court, and then in my local jurisdiction, the Fifth Circuit. And so you do that a lot by reading kind of dissents and concurrences, trying to look for growing kind of minority, maybe a consensus that's growing that may become a majority if the composition of the court changes soon. And so just to give you a sense of kind of where I have been coming from and why I worry about federal firearms crime is I live in Lubbock, Texas. I've been to Wyoming 3 times and had a wonderful time each time, but I'm stuck kind of at the top of the Texas Panhandle, near the top. and in what we call the Northern District of Texas. And if you look at the statistical breakdown of the types of crimes, federal crimes you see in the Northern District of Texas, you'll see that drugs is king, which is true in almost every federal district in the United States, except for the Eastern District of Missouri. But immigration, which has really dominated a lot of federal um, prosecutions in Texas, is actually not number two in the Northern District. Firearms crimes are number two, at least in fiscal year 2021, making up 18.6% of all prosecutions. Now, I'll tell you that that's a high percentage because if you look at the top 5 districts in the United States in 2021 for federal felon in possession prosecutions, which is by far the most common federal firearms crime prosecuted, Northern District of Texas, where I live, is tied for second in terms of number of prosecutions. The only one that's ahead of it is Eastern District of Missouri. And so, at least according to Westlaw, I filed a lot of briefs and represented a lot of defendants in my day. According to Westlaw, 410 briefs filed, at least last I looked it up. And I'll tell you that of those 410, probably 300 of those clients are still in federal prison. And a substantial percentage of that 300 are in prison for the mere possession of a firearm. And that's one of the important distinctions, I think, that we need to make when thinking about federal crime versus state crime. When we think about firearms prosecutions, we often have in mind a shooting offense, someone that's maybe on the most extreme example, like terrorism or a school shooter, or kind of in the more kind of garden variety example, maybe gang violence or some sort of interpersonal violence. But at the federal level, almost every prosecution is for the mere possession of a firearm. Most shooting offenses are prosecuted at the state level, and both of them usually have concurrent jurisdiction over pretty much anything that happens. Well, kind of going through a lot of these cases, eventually I started to think about it in terms of the Second Amendment, and that becomes kind of an important part of the story. I was appointed on a case called United States versus McGinnis, probably in 2019 or 2020. And it was in that case that I first made the argument that the US Supreme Court should change its analytical framework for how it thinks about a Second Amendment challenge to a federal firearm statute. So in some ways, it was kind of, I was making the Bruin argument before Bruin. I think I filed my cert petition in late 2020. And the Duke Center for Firearms Law did a blog post on it, thinking maybe this was the case the Supreme Court was going to take to reconsider how we think about the Second Amendment. Ultimately, that didn't happen. But then later, after Bruin came out, I was appointed on United States versus Rahimi, which was out of Fort Worth, Texas. And there we kind of re-raised the same arguments I had made before in asking the court now not to change the framework because the court had already done so in Bruin, but rather to apply it in such a way to a particular firearms crime in order to hold that it's unconstitutional. Rahimi, you probably read about in the news. It's the one dealing with domestic violence protective orders. I will say, we can talk about Rahimi if anybody's interested, that it was hard for me to find a headline that I felt kind of accurately reflected what the case was really about. But at any rate, I ended up working on this case and then had to hand it off to someone else for oral argument because I took the full-time job at the law school while the case was pending. But I did get to co-write the brief, and so I was able to go and travel there for the oral argument. So that's kind of the reason I got interested in firearms crime and federal crime policy, just based on all of these past experiences I had had in cases that I'd been appointed on. And just for people that haven't worked in this area, there's kind of 3 big pillars of federal firearms crime. There's the list of prohibited persons, most commonly felon in possession of a firearm. Then there's kind of a unique crime that we just call 924C, which is possession of a firearm in furtherance of a crime of violence or drug trafficking crime. This is what my Supreme Court case, United States versus Davis, was about in 2019. And then the other big one that the Supreme Court has probably heard more cases on pound for pound than any statute in the US Code is the Armed Career Criminal Act, 924E, which is not a substantive offense, but rather an enhancement if you have certain qualifying predicate convictions. So these are kind of the big three. And so when I was reflecting on kind of how we got here, I spent a lot of time trying to think about it in terms of kind of these different ways that academic types think about things. Public policy in terms of violent crime, federalism, mass incarceration, disparate racial impact. What direction is the Supreme Court going? And there's really interesting points of entry on all of these things. But when I read a book like The New Jim Crow by Michelle Alexander, and it talks about the disparate racial impact of crime policy, you don't read anything about firearms. In fact, everything you read in this book has to do with the war on drugs. Yet today, the driving force in mass incarceration, particularly as to Black men at the federal level, is not drug prosecution, but is rather firearms prosecution. And so I think there is kind of people have ignored this point of connection between war on drugs and what I call war on guns here in terms of its effect. And then when I would talk to kind of old timers at the Federal Public Defender's Office, people who were reaching retirement age, maybe 60 to 65 years old, one of the common stories that they would kind of tell is how things are so much different today than they were before when they first started. And then I started to imagine to myself, well, what if I went back to when they started and talked to the old timers who were retiring then? Would they say the same thing about how much things have changed? And then if you go back even another generation, would we be repeating these same sentiments about how different it was when I started? So I started to look into as much statistical information or data as I could. And what's wonderful about federal crime policy and federal crime prosecution is there's an enormous amount of data that different agencies are required to keep by statute. So for example, when Congress created the U.S. Sentencing Commission in 1984, Congress required the Sentencing Commission to issue annual reports with all of the statistical information. Meanwhile, the Bureau of Justice Statistics keeps a lot of information, as well as the administrative offices of the courts. So if you kind of know where to look, you can find this treasure trove of data and information to kind of reconstruct the past of how we got to where we are today. And when I started to do that using the really, really good data we have from the Sentencing Commission, I realized that things are really different today than the way they've been before. So if you were to look at the overall number of federal firearms prosecutions, almost every one of which results in a conviction, you'll see that in 1989, for example, firearms crimes were not heavily prosecuted. And in fact, if we were to recreate that pie chart, where in the Northern District of Texas, firearms prosecutions are number 2 today, they would be 5 or 6 or 7 or 8 if we went back to 1989. Fraud would be much higher, for example. Other organized crime would be higher. And then if we went back even further to the 1960s and 1970s, you would see that these crimes were almost never enforced. Same is true for 924C, which has been kind of one of the most draconian offenses that we have in the US Code, although it was modified somewhat in 2018. It was created in 1968, but even as recently as 1984, very infrequently charged. And then, of course, the Armed Career Criminal Act, the big one of them all, you didn't really see its use until 1991. And then it's decreased today for a variety of other reasons that we may be able to get to. So kind of going back to look at the progression or the trajectory of these 3 main firearms offenses, we do see quite a bit of changes over time. And one of the things I've been trying to figure out in the article that's the basis of this, and then the one I've sent since then, is how do we account for all of this? When that line goes up, why is it going up? Who is doing what that's causing that? And then when the line starts to go back down, well, what's causing that? Someone is taking some action, and perhaps we can measure it and identify what that happens to be. And so when I started to look at these charts and saw that something really was changing around 1991, particularly if you look at this last chart dealing with the Armed Career Criminal Act, I started to think, well, maybe we shouldn't think of the history of federal crime policy as one kind of unified whole, but rather think of it as kind of different chapters or acts in a larger story, with each one having its own characters, its own villains, its own ironies, and see if that's maybe a better way of thinking about the last 100 years or the history of this type of crime. And what I realized is that when you start to think about it that way, kind of like Star Wars: A New Hope, we're really starting here in Act 4 of the story. And then if we go back and kind of reconstruct it, we see kind of this conceptual clustering at different periods, where the executive branch and also Congress were concerned about very different things in each one of the periods. And different people were kind of pulling the levers of power for different reasons in all of these times. And you'll see that it kind of starts to create a story. We don't know how the story is going to end. I have some very recent thoughts about that. Not going to end exactly the way I thought it might. But when we start to think of the 5 acts of this story, each one kind of has its own theme. And in the article I wrote, the first one, I kind of try to give some insights into the theme of each one of these eras. But each part also has its own author. All 3 of the first acts, really from 1919 to 1988, were written by Congress. Very little involvement from the executive branch and almost no involvement from the courts. And then it wasn't really until 1991 that you start to see the executive branch really taking over as the author of this period, the driving force. And then only in the very recent years since Bruin do we start to see the courts getting super involved and really kind of writing the end of this story. So this is how I've been trying to conceptualize it kind of in terms of this story, in trying to create kind of this conceptual historical framework for thinking about things. And I think the big takeaway is the period that we're in now is distinct and unique from the periods that have come before. In fact, when I've talked to the old timers and they said it used to be different, they weren't making it up. In fact, everything that they told me was exactly true, perhaps even more true than they realized. So going back kind of with a mind toward these 3 big pillars of the federal firearms scheme, I did want to take a few moments to kind of highlight some of the interesting points, or maybe a story or maybe an irony along the way in each one of these periods, to kind of show you what I mean by it being really different than what it is today. So starting with this first act, which I call the era of uncertainty, 1919 to 1938. Well, in that period, Congress passed 4 different laws, culminating in the 2 big ones from the 1930s, the National Firearms Act, and then the big criminal law, the Federal Firearms Act of 1938. In there, we had a unique set of concerns. We had a unique hero. We had a unique villain. And then we had a unique kind of tool of destruction. So our hero, at least from the the Department of Justice perspective, is Homer Cummings, who was the first Attorney General under FDR. And he's been kind of, in retrospect, viewed as the greatest proponent of firearms regulation of anyone in the Department of Justice in history. The great villain that Homer Cummings was out to stop was John Dillinger, who's pictured here in the middle. And he characterized John Dillinger in his testimony before Congress in 1934 as the leader of this roving gang of 500,000 armed criminals who are using these newfangled automobiles to cross state lines to avoid federal detection. and commit crimes in ways that we've never seen before. And in fact, the tool that John Dillinger was using to commit these crimes is pictured here on the right side of your screen. And that's actually not a bad guy that's holding the Tommy gun. That's General Thompson, who either invented or the Tommy gun is named after, the Thompson submachine gun. And so this is what Congress was worried about at this time. But when Homer Cummings went before Congress, Homer Cummings said, I would love to use the Commerce Clause to pass expansive firearms crime, but I don't think the Constitution would allow that. So we're only asking you to pass new laws using Congress's taxing and spending power. We can treat firearms similarly to the way we treated Al Capone, where we can treat it kind of like tax evasion with a failure to register. We don't need to go after people for the mere possession of a firearm. And he describes this quite explicitly in his testimony. He says, if we made a requirement that you had to get your fingerprints taken to possess a firearm, we know the bad guys won't ever go and get their fingerprints taken because they would essentially be turning themselves in. And then if we created the penalty for not having a registered firearm, the same as we would want to for being a bad guy with a gun, well, then we can catch all the John Dillingers this other way, and we can do it without using Commerce Clause power. We can do it just using taxing and spending power. Eventually, after the composition of the court changed in 1938, Congress did start to use Commerce Clause power and created the first major piece of crime legislation dealing with firearms, the Federal Firearms Act of 1938. But then from 1938 and really until it says 1961, but only something minor happened in 1961. It wasn't until 1968 that Congress acted again. So you had a 30-year span of silence in terms of legislation, but you did have a really significant conversation that started to happen in the late 1950s and the early 1960s. And it dealt with a different set of characters. We no longer were dealing with Homer Cummings and John Dillinger and the Tommy gun. Here we have a different collection of heroes, Thomas Dodd, Russell Long. And then we have a different collection of villains, the kind of famous assassins in political history, Lee Harvey Oswald, James Earl Ray, and Sirhan Sirhan. And starting in the late 1950s, Thomas Dodd, and in connection with then Senator John F. Kennedy, started to try to kind of get people in support of legislation to prohibit the importation of foreign firearms. Thomas Dodd, who was a senator from Connecticut, and JFK, who was senator from Massachusetts, had an economic incentive to prevent the importation of these foreign-made firearms, because they had become so cheap as a result of World War II and of the Korean War, where you had these European or Asian wars where there were so many firearms manufactured, sometimes cheaply, and people were turning to purchase them and import them rather than buy them from American-made manufacturers, largely located in places like Connecticut. And so you had JFK, excuse me, and Thomas Dodd trying to kind of push this legislation. And then eventually Thomas Dodd becomes the chair of probably a fairly insignificant Senate committee, but then uses it to have public hearings on the role of firearms in juvenile crime and other things to try to push for this ban on imported firearms. It ends up not really going anywhere, and JFK ends up having to hand off all of that to Thomas Dodd when he becomes president of the United States and is sworn in January 1961. Thomas Dodd keeps pushing it. And then ultimately, as we know how this part of the story ends, JFK is assassinated in November of 1963 in Texas, in Dallas, Texas. And that gives a great opportunity for Thomas Dodd to advance some of this legislation and then do even more with it. Why? Because what was the gun that Lee Harvey Oswald, or at least the one that was found without taking a stand on a conspiracy theory, I think it was Lee Harvey Oswald. But what was the firearm that they found on the fifth floor of the school book depository? Well, it was a foreign made, Italian made rifle that was mail order purchased from a sporting goods store in Chicago, Illinois. And this was something that Thomas Dodd could just hold up and say, this is the very thing I've been trying to stop from happening. And now we have a dead president of the United States. And it was at this time that Russell Long, who was the son of Huey Long, but Russell Long is the second person pictured here, and others started to push for new firearms legislation to try to prevent from happening what had happened to JFK. But Congress was unwilling to act from 1963 to 1968. And it took two major events to happen in 1968, almost back to back. The assassination of MLK by James Earl Ray, who's featured there in the center of the villains, and then the assassination of Robert Kennedy by Sirhan Sirhan. Congress finally got the will to act. And eventually it was Russell Long that took an amendment to the floor of the Senate and said, this is what we need to do. We need to create a robust list of prohibited persons. And these are the persons that it should be a crime for them to merely possess a firearm. And he goes through the characteristics of Lee Harvey Oswald. He goes through the characteristics of James Earl Ray, whom here he calls Galt, which was James Earl Ray's alias, and says, okay, we know James Earl Ray or Galt was a convicted felon, so we need to make sure they can't possess a firearm. We know that Lee Harvey Oswald renounced his citizenship, so we need to make sure they can't possess a firearm. We know that he was other than honorably discharged to the military. We need to make sure they can't possess a firearm. And kind of in response, in this what I call the era of impulse, to very specific historical events, Congress creates this long list of prohibited persons that it's now a federal felony for them to even possess a firearm, irrespective of whether they misuse it at all. And at the time, the senator said, well, this is an interesting idea. We need to think about it. We need to talk about it. And then in the congressional record, it has kind of this very unique portion of what happened in the transcript. And several senators start yelling, vote, vote. And then everybody just kind of throws up their hands and passes it. And later, the US Supreme Court in two different cases, one called United States versus Bass in the 1970s, was highly critical of this process. They said it lacked deliberation, and we cannot, as a result, rely on legislative history to know how strongly we should hold on to some of these firearms crimes. But so much happened in 1968 as a result of Russell Long and some of these other folks, the creation of 924C, the creation of these prohibited persons, and all of these other things. And so the third era that we get to didn't happen really until the early 1980s. So again, we have this big span of silence from 1968 to the early 80s. None of these crimes, by the way, that have been created were being enforced hardly at all. And it became a question of the executive branch responding to different concerns, different historical concerns again. And we had different heroes and we had different villains than we had before. Here, of course, the person that was creating, the atmosphere for thinking about crime policy was Ronald Reagan, which he did very effectively in a series of speeches in 1981 and 1982 and 1983. And then you have enormous influence of Arlen Specter. Arlen Specter, of course, had been the state district attorney for Philadelphia. Of course, when he was district attorney, the last thing he wanted was the federal government telling him what to do, how to run his office. And then when he becomes the senator from Pennsylvania, he decides that the federal government is the cure to all problems. And we'll talk about his role, but he became the author of the third pillar of the federal firearms scheme, which is called the Armed Career Criminal Act. He literally authored it. But we're no longer worried about John Dillinger or the Tommy gun. We're no longer worried about Lee Harvey Oswald or presidential assassins. Now we're talking in these speeches and in the rhetoric about street crime. And the way that Ronald Reagan and the way that Arnold Specter kind of characterized this is their understanding of the way violent crime worked was you're going to have anywhere you go, you're going to have good guys and bad guys, you're going to have criminals. But they believed that there was a core kind of group of hyper violent criminals that were kind of doing all of the violent crime. These recidivists, these repeat offenders. And this is in 1984, and in some of the legislation you see there, and then in 1986, is the first time you start to see the big, heavy use of mandatory minimums and of recidivism statutes, where not only are you going to get a mandatory minimum in many instances, but it's going to be increased dramatically if you have certain prior convictions that meet certain characteristics. That's where you start to hear terms like violent felony or crime of violence or aggravated felony, depending on what statute you're looking at. But those are all things that started to appear and started to get used more frequently here. So Reagan was giving these speeches. And then Arlen Specter wrote an article calling for a new federalism in criminal law. And so I think this is significant to kind of make the point that things really used to be different. We didn't used to think about crime enforcement as happening primarily at the federal level, not for street crime. Why? Because you don't have FBI agents patrolling the streets. You don't have DEA agents patrolling the streets. You have local law enforcement that are investigating crimes, that are arresting people. Then you have local prosecutors that are prosecuting people. And it wasn't really until the early 1990s that some of these crimes started to get funneled to the federal prosecutors. Arlen Specter talks about and advocates for this change in 1984. And then when he finally convinced Reagan, by the way, the first time vetoed the Armed Career Criminal Act based on federalism concerns, Arlen Specter, excuse me, I think I was calling him Arnold Specter before, so I hope you'll forgive me. Arlen Specter, he rewrote it, and then the way he sold it to Congress, and this is from his testimony, or not his, he wasn't under oath, but this is what he said when he was trying to get people to vote on it. He said, the great thing about the Armed Career Criminal Act is that we'll never even have to use it. It's so draconian, it's so onerous. We just have to use it in a few, often less than 1% of all instances where it could be used, to send a message to the criminal elements that you need to plead quickly to your state charges because you don't want it to get taken federal, because you don't want to have to contend with the Armed Career Criminal Act. So the beauty is kind of like a nuclear bomb, is that as long as we have it, we'll never actually have to use it. And when you look at the statistics for the Armed Career Criminal Act, well, that was true. That was true in 1984 when it was created, in 1985 and 86. And then something really different started to happen in 1991. Where kind of like you have a new administration and looks into the warehouse where all the nuclear bombs are and says, well, what are all of these doing just sitting around? We wouldn't want them to go to waste. And that's kind of what happened with the Armed Career Criminal Act, where you had kind of the next generation of executive branch policy, the next generation of attorneys general. And this is where they really start to take a dramatically different eye toward federal firearms policy. And so we have all of these different things happening in the legislative branch, the executive branch, the judicial branch. And then we also have a different collection of kind of heroes and villains. But it's much different than what we saw before. It's a bipartisan group of people that think that it's important that we dramatically increase federal firearms prosecutions. A lot of these people you might find familiar. And then we have another bipartisan group that are saying, hold on just a second. Let's not go too far with some of these things. And so if we were to go to kind of the group of advocates, who do we see here? Of course, we see H.W. Bush and Attorney General Thornburg. Then we see a familiar face, perhaps. I think he might appear twice on here. Part of my screen is covered up. Bill Barr. Robert Mueller, who was the deputy criminal chief for the Department of Justice. Bill Clinton, now President Joe Biden, and Chuck Schumer were heavily involved in pushing these reforms to increase federal prosecution. James Comey, John Ashcroft, Jeff Sessions. So it's this part of this story is so very interesting because all of this stuff, these were the key players in basically 1989 through 1995 that created a lot of these, in my opinion, problems in federal crime policy. And they almost all have been dramatically in the news in the last 10 years. So it's kind of like this deja vu. But who are the reformers? I think this is absolutely fascinating. Who are the people that were saying, hold on just a second, maybe we're not taking the right approach here? Well, some of it's kind of predictable. Eric Holder, Dick Durbin, Cory Booker might be predictable as reform-minded people. But we also see Chuck Grassley here. We also see Mike Lee. We also see Chief Justice Rehnquist here, who in his end-of-year reports, when he was the chief, would often bemoan the use of federal prosecutorial resources to prosecute garden variety firearms crime. He always believed that that should have been left to the states. And to a certain extent, it kind of denigrated federal court to turn it into what he called police court. So very interesting kind of coalition here. Ultimately culminating in something called the First Step Act of 2018, passed in December of 2018, signed by President Trump. And so what's fascinating to me about all of this is it disrupts kind of our left versus right way or kind of bipolar way of thinking about things. Because the biggest piece of criminal justice reform we've seen maybe ever, although it didn't go nearly far enough, in my view, was signed by President Trump. And we've seen kind of a step back from criminal justice reform in the Bipartisan Safer Communities Act of 2022, signed by President Biden. Yet at the same time, both Trump and Biden prosecuted federal firearms crime at higher rates than any administration in history before. So we're still at an all-time high. The last time we had a president where it went down even a little bit was under President Obama and Attorney General Eric Holder. In fact, I want to see if I can find this chart because I don't want to take up all of your time, and I will never go over time in a CLE, I promise. And this shows you that it's never as simple, at least on this type of thing, as who's the president? Are they Republican? Are they Democrat? Because you really have to look at it more specifically about what are the particular policies, what are they doing, what are they saying, what are the instructions to the prosecutors, what is the political will of the time. We start to see our first dramatic increase under President Clinton. We see it go basically through the roof under President George W. Bush, really attributable to the policies of John Ashcroft. And then we see it kind of maintain but trickle down under President Obama, and then essentially skyrocket under Jeff Sessions and then Merrick Garland. So I see we have a note here. Maybe we have a question here.
I did put that in the chat, and I am a person that has looked at crime from a different perspective, mainly an environmental perspective. And I do believe that since World War II, we have missed the impact of putting lead in gasoline and taking it back out. And so a lot of these laws that we passed missed the point. And I guess that's the point of my little uh, uh, direction here, is that crime went down considerably once we took lead out of gasoline, and we made laws that didn't recognize that, and now we're stuck with them. But that would be a long conversation, and not many people want to have it. I put in some links. You can decide whether I'm incorrect in that assessment, and I've written a lot about it. But so I did want to hear this perspective, and I do think it's fascinating. But I'm just going to put my stuff in there, and you guys can take a look at it some other time.
Well, thank you for sharing that. And one of the things I think about a lot is maybe is consistent with what you just said, and I probably would have some follow-up questions for you, is when Congress passes law, and this is one of the big conclusions I've come to, Congress is often focused on ephemeral concerns. Something is happening right now. It's a pressing problem. What can we do to fix it? Here's something that would fix it. Pass a law. But what's not often thought about is generations from now, when the pressing problem not only doesn't exist, but has been forgotten about. Well, now you have these same laws still on the books that are affecting people in unpredictable ways. And it's kind of, you can always go back a generation before saying, if you knew what we're dealing with now, would you have done it the same way? You could ask that question about the framers in the way they wrote the Second Amendment. Maybe they would say we would have written it exactly the same way. Or maybe they would have said, knowing what you know, we would have done it a little bit differently. And so we often take kind of this myopic or short-sighted approach to legislation, believing that, well, if there's a problem that comes up later, Congress has the power to fix that problem. Just like the framers might have said, well, there's a mechanism to amend the Constitution. Well, when's the next time we're going to see a constitutional amendment? When's the next time we're going to see another piece of major criminal justice reform? Well, it will not happen until there's the political will to do it, a president who's on board, and a Congress that can communicate even remotely normally. So I think that it's misguided sometimes for Congress to only think about the present problem and not think about all the externalities down the line. A recent example of this is the Bipartisan Safer Communities Act, 2022. In response, at least this is the way the rhetoric went, to the horrible school shooting in Uvalde, Texas, which is not far from where I live, Congress included in this bill an increase in the statutory maximum punishment for every normal, typical firearms offense, felon in possession, from 10 years maximum to 15 years maximum, even if you have no prior convictions other than a single felony, even if that felony is nonviolent. And why did they say they're increasing it for every one of my clients from 10 to 15 years? They said, we're doing this for the children of Uvalde. Well, then I think to myself, well, I guess the school shooter was a felon in possession. I guess they were a prohibited person somewhere else on that list of everyone else who's going to be affected. And you look it up and they possess that firearm legally until they misused it. And so now I'm going to have 100 future clients who are subjected to an increase in their maximum punishment from 10 years to 15 years, most of whom merely possessed a firearm and never pulled the trigger, all because Congress acted to a certain extent rashly in response to a very unique, specific historical event. And perhaps that's also part of the theme that piggybacks on the comment that was made. So do we have another one?
Okay to talk?
Yeah,
Yeah,
go for it.
I'm sorry I was late because I was so absorbed in my delivery of my speed loaders and my pistol uh, locks. I live in Massachusetts. You can imagine what that's like.
Well, and I'll tell you, I lived in Boston for 3 years for graduate school, so I do know.
Yeah, I mean, as far as firearms. No, very minor point. This graph that's in front, it says federal firearms convictions. Looking from the bottom up, I'd like to see another graph, federal firearms prosecutions. Okay, that's enough for now.
Well, can I speculate on that a little bit? Of course, the data that we have from the U.S. Sentencing Commission is called the Sentencing Commission because the data comes from sentencing hearings, the judgments. So they are all convictions. But the way that these cases who are originally investigated and taken at the state and local level get taken to the federal level is the federal prosecutors get to decide what cases they want to take. So there's a communication that's happening between the federal prosecutor and the state prosecutor. And they'll say, I want that case, that case, that case, and that case. And they have, if someone told me there's a 100% conviction rate for felon in possession of a firearm, by the way, 97% are guilty pleas. 3% are going to go to trial statistically. And if someone told me there's 100%, I would say, I don't believe you, but it's probably more like 99.9%. So this is a very provable offense, right? Because you can do it with constructive possession or actual possession. It's very easy to prove a prior conviction for a felony. The only thing that disrupted it is a case that came out a few years ago called Rahafe, which is a case where the U.S. Supreme Court held that there's another element that the government has to prove that we didn't know about before, that the defendant actually had subjective knowledge of their prohibited status. Of course, Justice Kavanaugh says in his concurrence, this is very easy to prove in 99.9% of cases. But if people are getting off now, it's on a Rahafe style evidentiary argument. But good point, and I've thought about that, and I wish I had an overlay of prosecutions versus convictions, but I'll just tell you from experience, I think they would look very similar.
And oh, is it okay to ask a question? Or?
Please, yeah.
Thank you. So I am a public defender out of Michigan. So I think looking at the history federally is interesting because it tracks a bit with what's happening in at least my state. I'm wondering, just given the language in Bruin around how we're doing this new historical analysis, you start with the first act being during the interwar period. That to me on its face feels like it's decidedly outside of the national tradition of firearms regulation that is specified by Bruin, which ends somewhere around the incorporation period. So I'm just wondering how, if we know that status-based prohibitions, don't occur until decades after, when the Supreme Court is saying we have to stop considering whether this evidence is relevant. Do you see the Supreme Court honoring what it said in Bruin? Because it just seems to me that, I mean, to your point about things being myopic, I think even Bruin almost addresses that of, there are certain issues that are historical, which require like distinctly similar means, and then there are issues that might be more modern. So you might have to adjust, but it seems like the possession of a firearm is historical, and if it was not, prosecuted until the mid 1900s, that just seems to be a bit strange to me that that's not more visible or apparent in Rahimi, at least.
Well, I'll tell you that Bruin is just a big lie to me at this point. And the reason for that is, Matthew Wright, who argued Rahimi last year, I was 6 feet away in the courtroom, and he made a joke, and nobody laughed. And he made a joke, but he said something that was true. He said, the tie I'm wearing today is older than 922G8, which was the statute at issue in Rahimi. So we're supposed to be talking about something that happened at the latest, 1868. But really, you want to go to the founding era if you can, according to Bruin. And we're talking about a prohibition on mere possession of a firearm while under a domestic violence protective order. Well, let me give you some facts. The first domestic violence protective order in the United States was created in 1970 in Washington, D.C. The first time we had any prohibition on the mere possession of something, people will argue some nuance about this, but it was really 1968 with the work of Russell Long. And yet we're supposed to be looking for historical analogs from so much further back. Well, if you read Bruin, they had an analog that wasn't that far off. Okay, they had something called the Statute of Northampton. They had some other things. And what Justice Thomas, who wrote Bruin, said is that's not close enough. And he had reasons, right? And then it comes around, okay, so we have a data point. We know at least what it can't be, what's too far. And then when you start to look at these recent 922G8, which is the one there, well, that wasn't created until 1994. So now our points of reference are 1968, 1970, 1994. And all of a sudden, because it's a criminal defendant and not a civil plaintiff, the Supreme Court takes just a really, really different approach to applying the same rule. And I will argue, I feel like given enough time, I could convince anyone, including John Roberts, that Rahimi fundamentally changed the test of Bruin. And they just said they were clarifying it, but they really changed it. In Rahimi, they didn't even identify an analog. They took two different analogs, Frankensteined them together, and then said it's close enough in a way that it never would have been close enough in Bruin. Never would have been close enough even if you go back to McDonald or Heller. So what Rahimi represents to me is something that you've probably seen many times, and I have as well, is a fundamentally different treatment of similar concepts in civil law and in criminal law. So in civil law, because I used to be a civil litigator, I used to work at a law firm years ago, you can have a 6-week trial, 6 weeks of evidence, and at the end, the Court of Appeals or even the district court is just really struggling over whether the plaintiff met the preponderance standard. But then you go to a criminal case and you can have a pre-sentence report that has nothing, almost nothing to it. And the court says, as a matter of just routine, well, that meets the preponderance standard because preponderance doesn't mean anything. That's how I feel about Bruin and Rahimi. The reason it turned out the way it did in Bruin is because it was a civil plaintiff. The reason it turned out the way it did in Rahimi is because it was a criminal defendant. And even if the court has to change the rules to make the outcome fit, the court's willing to do it. And so that's why I call Rahimi the modern Second Amendment, because it's made up in a way that Bruin is not. And I do think it's telling that Thomas, the justice who actually wrote Bruin, is the one dissent in Rahimi saying, that's not what I meant. I think he's exactly right. And so I don't get a lot of dates or phone numbers by talking about how badly Rahimi was decided. But I really do believe that.
I appreciate that. Thank you.
And thank you for what you do. Honestly, it's something that means a lot to me.
All right, so it's 1 o'clock. So if somebody has one more question, I think we've got a little bit of time since we started a few minutes late. But if not, we can wrap it up. All right, I think we are good to go. So thank you so much, Brandon. Thank you for everyone who hopped on. I apologize for the confusion with the link for some people. We will be posting this online to our video library at firearmsresearchcenter.org. Just because there were some communication issues, we're going to have our comms team send the video out to everyone who RSVP'd. That way you guys don't have to be checking to see when we upload it. So you'll be able to have it directly in your email when we get it up. And we're usually pretty quick on that. So look for that in your inbox. And thank you guys so much. Thank you, Brandon. And everyone have a good holiday.
Thank you all.
Thank you.